welcome to Mudra TV. Today we're going to discuss CRPC's landmark judgment Lalita Kumari versus State of UP and others. So we will get to the facts of the case really quickly. On 5th of May 2008, a minor girl aged 6 years went out of the house at 9 p.m. and did not return because she was kidnapped by local goons. Her father, Bhula Kamath, made unsuccessful attempts, and when he was unable to do so and find his daughter, he went to the police station to file a missing persons report in Loni, Ghaziabad, Uttar Pradesh. Now you may think he went there, his problem was solved, but that didn't happen. Police actually refused to register his FIR under section 154 of CRPC, and then he had to approach the superintendent for the same to file a complaint where a written report was being filed, but then no measures were being taken. So being disappointed by all of this, he went ahead and filed a habeas corpus petition under Article 32 of Supreme Court, which was a 5-judge bench for final judgment, which was declared, in which it was declared that the police officer cannot avoid the duty of registering an offense if the cognizable offense is disclosed, and actions will be immediately taken against such officers who refuse to take or register an FIR. So why is FIR so important? It is very paramount in criminal investigation because it sets the judicial process in motion, and also only when a police officer has all the facts with him before starting a case, he's acquainted with the facts of the offense and the details which is reported to him, he can then start his investigation of the case. Now we will go through what are the requirements of filing an FIR and how it has to be done. It has to be done promptly. A prompt lodging of all of this information of the commission of the offense at first glance has to be done in its true version without any kind of embellishments, which means you cannot, or the police officer cannot add anything interesting to make up or add more to the story. It has to be in its true version. Now, why does it have to be prompt is the next question, so that there is no possibility of an influence or addition which will be removed when the memory is fresh. Now, what is the procedure of filing an FIR, you may ask? Now, whenever the information has been given orally or verbally, now the police officer is bound to register an FIR, and such kind of substance of the information shall be done in a report or a book by him in a prescribed form, which is known as a station diary. The book is known as a station diary, and then he has to maintain the record of all of these reports, and then he has to initiate the investigation. He has to inform such and such to the all of those information that he has recorded to the magistrate forthwith. Now, the next question which arises, which is very important, is what can you do if your FIR is not registered? In the unfortunate cases where your FIR is not registered, you can send your complaint in writing or by post to the superintendent of the police, and if he is satisfied with your complaint, he shall start the investigation himself or order an investigation. Now, the second one is that he may file a private complaint before the court having the jurisdiction. You can also complain to the State Human Rights Commission or the National Human Rights Commission if you believe that the police has not done anything in the enforcement of the law, or he has done it in a very biased and a corrupt manner. Now, in Ramdev Food Products Private Limited versus Gujarat, which was a 3-judge bench in exercising the powers which is under section 156 subsection 3 of CRPC, it was held that the directions which are given under this 156 subsection 3 is to be issued only after the application by the magistrate when it is given, and cases where the magistrate has yet to determine the existence of sufficient grounds to proceed with such investigations. Now, in Suresh Chandra Jain versus State of Madhya Pradesh and others, it was the Supreme Court held that it was the duty of the officer in charge to register an FIR as soon as he comes to be aware of the commission of the crime. Now, what is the conclusion is that it is prudent to be cleared that the justice should not be denied to any individual by any prospect. And a crime against women, especially, needs to be looked at as a preventive measure or a preventive issue while performing any kind of criminal reforms. And it is very important to prevent crimes and pursue justice. It cannot be seen as a silver bullet. Crime against women cannot be resolved in the court of law alone. A holistic approach is what is needed. Thank you.